Really, we start with the PITT review of the flooding in summer of 2007. And that flooding caused considerable press attention, if nothing else. And you had pictures of a guy who built a moat around his house to try and get the floodwater off. And it was a heavy time. And what the PITT review did, amongst other things, was consider drainage on sites and say an important part of improving the management of floodwaters is to prevent it from entering the draining system and potentially overloading it. And this has been an issue with sewerage undertakers for some time. They say, well, yes, you can put surface water into our drains, but you shouldn't be putting land drainage into our sewers and sewerage systems. And as was rightly said, the sewerage system was designed in the Victorian era, and a lot of it is becoming overloaded with surface water runoff entering either surface water sewers or combined sewers. And therefore the PITT review went on, sustainable drainage systems, SuDS, are a way to deliver this. The government intends that local authorities should be responsible for adopting and maintaining new and redeveloped sustainable drainage systems on highways and the public realm so as to increase their uptake and effectiveness. That then moved on to Schedule 3 of the Flood and Water Management Act 2010. And this was a nice bureaucratic system where, in conjunction with the planning system, there would be SuDS approval boards run by local authorities where a developer, or indeed anybody doing construction work, and notice the term construction work, it's not new development or anything, any construction work, possibly coming on from redevelopment of a school, for example, that would be construction work. It would have drainage implications because school playgrounds are tarmacked and all the rest of it. Do you, in redesigning your school, redesign for SuDS? So wider than just development, and there would be national standards for sustainable drainage so that everybody was singing, as it were, from the same hymn sheet. That got hit by the pickles bomb. Essentially, the Conservative government didn't like a new layer of bureaucracy. The whole idea of the government coming in was to reduce red tape, and therefore Schedule 3, although it's still on the statute book, it's very unlikely to be implemented, and it's been replaced by the planning system. And I'll leave this slide on for a minute because on the 26th of April this year, there was a debate in the House of Lords on sustainable drainage, and what a number of opposition peers said, well, this was fine, and yes, it reduced bureaucracy, but the problem is it had also blown a gaping hole in the development of sustainable drainage systems because developers now can say, well, yes, we see the planning policy, we introduce SuDS unless it is unreasonable to do so. Developers say, yeah, it's unreasonable to do so, no more SuDS. And we'll come on later to the outcome of that. However, having said that Schedule 3 is completely gone, that may not be quite right. The definition of sustainable drainage in Schedule 3 means managing rainwater, including snow and other precipitation, with the aim of reducing damage from flooding, improving water quality, protecting and improving the environment, protecting health and safety, and ensuring the stability and durability of drainage systems. And in the only case on this so far, the Manston Action Group case that's in the guidance note, there, at paragraph 39, counsel for the claimant said, well, this is the definition in the Act, and this is what the court should follow. And at paragraphs 83 to 85, the judge said, yeah, well, maybe. But it is still there, and I think if you are looking at what is sustainable drainage, which may well come up in the course of negotiations and whatever, the Act is a good place to start. It may not be the end of the story, but certainly it's worth looking at. But again, always remind the client it's not in force and it's unlikely ever to be in force. What the policy is after the Pickles bomb is the planning policy he enunciated in the House of Parliament. We expect local planning policies and decisions on planning applications relating to major development. And that's in the General Development Order, developments of 10 dwellings or more, or equivalent non-residential or mixed development, to ensure that sustainable drainage systems for the management of runoff are put in place unless demonstrated to be inappropriate. And I don't think a developer can come along and say, well, here's my site, you're telling me I'm going to put 100 houses on it, you're telling me I've got to sacrifice 20 of those so that I can put a sustainable drainage system in place. That means the development is unviable, therefore sustainable drainage systems are inappropriate. It's not that simple an equation. You've got, I think, to, if you're acting for a developer in these circumstances, the developer has got to put up a technical reason why sustainable drainage systems are inappropriate, rather than simply saying it makes my development unviable. That hasn't been tested by the courts. The court may say, well, you've got to look at the economic side of things. The economic side of things can mean that a development is inappropriate. But I would think the unless demonstrated bit must mean that there's got to be some sort of technical input in there as well. I don't think you can simply say it's economically unviable. And you've got draft planning conditions. I mean, this is a planning condition from South Cambridgeshire District Council. The development hereby approved shall be carried out in accordance with the details submitted in the SuDS Management Plan. What is a SuDS Management Plan? It is basically not just this is the SuDS way of putting in. It's much more about how we're going to maintain it. And indeed, you can see later on, approved by Anglian Water, so you can't just waltz in with your SuDS management plan. The development shall be maintained in accordance with the management plan hereafter. Examples were given about the cutting of grass. Well, okay, who cuts the grass, how often, who pays for it? That sort of thing would have to be in the SuDS management plan. Similarly, the dredging of any sort of drainage ditches or whatever would have to be in the management plan. And it would have to say who is paying for it and who is going to do the work. The reason for the planning condition: to ensure that measures to mitigate flood risk on the site once the development has been completed are fully implemented and maintained in accordance with the local plan policies. And so when in the guidance note we talk about the solicitor's job is to have a look at the local plan policy, in my view the client would have to be advised as to what policies NE 9 and NE 11 mean and how, if necessary, they're going to be complied with or should be complied with. And I was talking about major development. What about minor development, development that isn't major? There you've got the building regulations. And in in the approved documents, this comes from approved document H2, rainwater soakaways, and bear in mind that there are other bits of the approved document dealing with other aspects of buildings, but rainwater should drain to an adequate soakaway or some other adequate filtration system, or where that is not reasonably practical. And there again, reasonably practical, I think it's more on the technological side of things, rather than, oh, it's not economically viable. You've got, I think, again, to look at what is the geological situation, what are we actually dealing with here. If it can't go to an adequate soakaway, a watercourse, or where that is not reasonably practical, an appropriate sewer. And bear in mind, we were talking earlier about drainage to a water system. And yes, you've got to get the landowner's permission. You've also got permission, may need to get an easement to discharge into the water system. If the water that you add is going to increase your burden on a downstream owner, then you may very well need to have some sort of easement, some sort of right to put your extra water into the watercourse. So there is that aspect of it there. And then finally, in the last resort, an appropriate sewer. The sewer undertaker is likely to come along and say, well, you can do it in a surface water sewer if you must, given that you pay us a certain amount, but we're not going to let you do it into a combined sewer. We're certainly not going to let you do it into a foul water sewer. So that's that aspect of it. We talked a bit about the duty of care, and we go into in the paper in a bit about the duty of care. There's a common law duty of care and there's a professional duty of care. Common law, recent authority, but I mean, you always quote from the recent authority. This actually doesn't say anything very new. First of all, you've got the client who comes along and says, what must I do to be saved? I haven't a clue what I'm doing. Please, Mr. Solicitor, advise me. An inexperienced client will expect to be warned of risks which are, or should be, apparent to the solicitor but not to the client. So clearly there, I think, you would have to take the client through the SuDS, particularly if he's all happy and bouncy and saying, I'm going to put up 100 houses on my site, I'm going to make loads of money, and you've got to say to him, well, no, you may only actually get 80 because of the SuDS problem. Any client is going to want to know that right from the start. He doesn't want to have his architect design a 100 house site, go to the planning people and be told by the planning people, well, what about SuDS? And similarly, I know what I'm doing, I can't afford to spend too much. The law will say an experienced businessman will not wish to pay for being told that which he or she already knows. And an impoverished client will not wish to pay for advice which he or she cannot afford. But at the same time, if this is going to have an impact, and bearing in mind the cutting edge, if you like, of SuDS, it's probably sensible to say to the experienced businessman, well, okay, you know what you're doing, you're aware of SuDS. And if he says, yes, I am, get on with it, you say, fine, okay, you've had my advice, or you've been warned off about it. But I think you probably do have to go through that stage, particularly in a development like this, where this is new law. What about the professional duty? And this comes from the 2015 competence statement in the Law Society guidance. Develop and advise on relevant options, strategies and solutions, including understanding and assessing a client's commercial and personal circumstances, their needs, objectives, priorities and constraints, ensuring that advice is informed by appropriate legal and factual analysis, identifying the consequences of different actions. How does that differ from the common law side of things? It's always a bit difficult. You can always turn up and someone complains and you say, well, I fulfilled my common law duty. Is a fairly good defence. But it is always arguable in these circumstances that you should go a bit further. And again, I think the sign-off thing is saying to the client, well, you're aware of the SuDS situation. If he says yes, you can say, well, fine, I've dealt with that. But it is there. What about SuDS maintenance? This is a problem. People do come along and say, well, okay, we've got this SuDS. Who is going to maintain it? And the doctrine of estates rent charges has come back recently. I mean, under the Rent Charges Act 1977, the creation of new rent charges is prohibited. But in a recent authority, Camwell Estates Limited against Smith Brothers Farms, the Court of Appeal looked at this again and said, well, the key question is whether the case falls within a special exception from the general prohibition made for estate rent charges in Section 2 of the 1977 Act. They may still be validly created for limited purposes. The relevant purpose is contribution towards the cost of performance by the rent owner of covenants for the provision of services for the benefit of the land affected or for the benefit of that land and other land. And that, I would have thought, clearly covers a SuDS system. And an estate rent charge could be created by the developer in the favour of a management committee or whoever you're going to set up to run the site, so that the maintenance aspect there is covered. Finally, what is the future? I talked about the House of Lords debate. in April, and they were debating this amendment to the Housing and Planning Bill, where a person may only exercise the right under Section 106 of the Water Act, Water Industry Act 1991, to connect to public sewers in respect of surface drain water if the relevant drainage system is designed and constructed according to the SuDS system, in effect. That didn't pass, but what you did get in the Housing and Planning Act is Section 171, Sustainable Drainage. The Secretary of State must carry out a review of planning legislation, government planning policy and local planning policies concerning sustainable drainage in relation to the development of land in England. No date for that, but the government did say that this will happen in 2017. Obviously, that may say, well, there should be new legislation, particularly given what is being said about the uptake of SuDS in the light of the abolition of, or the effective abolition of Schedule 3. So you're probably looking for legislation somewhere 2018, 2019. That might move on to retrofitting SuDS. So far, we've been talking about development and planning and new buildings. What about retrofitting? This is an extract from the London Draft Sustainable Drainage Action Plan at page 27. The expectation is that where opportunities arise to incorporate sustainable drainage as part of other required maintenance, repair, refurbishment or replacement of facilities, sustainable drainage options are duly considered and implemented where practical. There may still be some initial additional cost involved in such measures, but this will be marginal in most cases, and there may be opportunities for some sustainable drainage options to offer cost savings. And so, for example, I come back to my school example. You're redeveloping a school. You've got the tarmac playground. Do you replace the tarmac with more permeable surface, for example? Whether the review, 2017 review, will deal with retrofitting, I don't know, but I would suspect it's likely because it is the next step. And therefore, we're not just looking here in the medium term at new development, but we're also looking at retrofitting of existing developments. Thank you.